Welcome everyone. Thank you for joining us. My name is Nasim Kurosh. I'm with the Baha'is of the United States at the Office of Public Affairs here in Washington, D.C. I would like to welcome you all on behalf of the Washington Working Group on the ICC, on the International Criminal Court, otherwise known as WICC. WICC is a nonpartisan, informal, diverse coalition of NGOs in Washington that believes there's strong U.S. relations. The ICC is at the benefit of the world and the U.S. in particular, and we work to promote a strong and close relationship between the U.S. and the International Criminal Court. And so we want to thank you for joining us today at this briefing on the ICC and the U.S. relationship with the ICC. And we want to thank Representative Jim McGovern for providing the space. And we're very pleased to have with us here today Ambassador Stephen Rapp. And to introduce him and set the stage for our program today, I'm going to turn it over to Kip Hale with the American Bar Association.
Thanks, Nasim. And first of all, thanks for everyone to be here. Great to see so many familiar faces. And it's also great, Ambassador Rapp, that you're here. There's few people, if any, who could brief Capitol Hill on this topic better than you. So we're really pleased to have you here. Just one quick housekeeping measure. There is a sign-in sheet in the back for the WICC. It's really important for us to, everybody let you know about our updates, and even if you don't like the ICC, if you like the ICC, great. But please do sign in the back. So the purpose of today's briefing is to, again, to discuss the ICC and US-ICC relations, particularly with Capitol Hill staffers. But again, of course, we've opened this open to the public, and we really like everyone's input. And just a little rough outline of the agenda today. To lighten the ambassador's load and also to make sure we're all on the same page, I'll talk for 5 minutes or so about the ICC, about US-ICC's relations, and that way, the ambassador, you'll be better positioned to get your insight on all those more specific issues. I'll ask a few follow-up questions, and then I'll open it to the audience. So as Nasim nicely introduced me, my name is Kip Hale. I'm Senior Counsel at the ABA Center for Human Rights, which is here in Washington, D.C. I'm also the Project Director of the ABA International Criminal Court Project. Now, the ABA, with its nearly 400,000 members, is the world's largest professional organization, volunteer membership-based. And the ABA's institution, its House of Delegates, since 1978, if you believe it, has passed pro-ICC policies, and that's gone throughout the negotiations and after the passage of the Rome Statute, and then in currently 2008, we've had ICC policy urging government to have stronger relations with the court. In furtherance of those goals, the ABA Center for Human Rights has established the aba-icc project. And just briefly, I'll say the two main purposes are to strengthen the legal operation of the court, and then additionally to help strengthen US-ICC relations. And we do that by offering legal trainings to the court judges and staff. Additionally, we do best practices workshops, dialogue forums, where ICC stakeholders from both sides of the Atlantic can meet and discuss relevant issues. And then additionally, advocacy and education, through WICC, the ABA is really happy to have this event today. So let me just quickly go through the genesis, the story, so to speak, of the ICC, so we're all on the same page, and then US-ICC relations, and as I said, I'll turn over to the ambassador. So to start, the story of the ICC begins with Nuremberg. Begins with the post-World War II accountability efforts. And Nuremberg, again, was where the Allied forces joined together to do what they all could have done individually, but to try the Nazi leadership. And there was, of course, its sister tribunal in Tokyo. And then after those tribunals, there was various within all the Allied zones. Now, there is some legitimate concern about what the Nuremberg Tribunal did, but putting those aside, it was as we'd say, a Grotian leap forward in international law. The idea that individuals could be held responsible for violations of international law, superior orders, and your government position were no longer a defense. And then also really the first iteration of the crimes against humanity, a category of crimes. And so, post-World War II and post the Nuremberg, there was the Cold War that put a kind of a halt to this idea that the international community could get together and hold individuals accountable for the worst of the worst crimes. However, we did pass the Genocide Convention, and then also war crimes were developed further by the subsequent Geneva Conventions. Now, that all sort of ended with the end of the Cold War, and unfortunately the events that occurred in the former Yugoslavia. The UN, by resolution, created the International Criminal Tribunal for the former Yugoslavia, and then subsequently that, and this again is the early 90s, is the International Criminal Tribunal for Rwanda, where Ambassador Rapp used to work as well. And so these courts were, again, ad hoc tribunals that were started up by resolution. And we could have a whole day talking about these courts, but they had very slow starts, but were incredibly important for jurisprudential reasons, have almost perfect arrest records, and have done quite a bit for reconciliation and reconstruction, in part with other activities in those countries. Now, that gets us to the ICC, particularly, and I don't want to overlook the hybrid tribunals, which of course are important. The special court for Sierra Leone, where again Ambassador Rapp used to be, and myself, I was at the extraordinary chambers in the courts of Cambodia. These hybrid tribunals were beginning as the ICC was being negotiated, and also they established after the court itself. But they, of course, jurisprudentially and other reasons, showed the international community's resolve on these types of issues. Now, with the kind of the problems with ad hoc tribunal, meaning that the logistics and the finances of always creating tribunals after every one of these conflicts, the international community decided to start negotiating actually something that had been going on for decades at the UN Law Commission, when that was a multilateral treaty to create the International Criminal Court. And so through the beginning of 94 was when that effort started, in 92, 94 started in earnest. And it culminated with 5 weeks of difficult negotiations in Rome in 1998. I always find it interesting to say difficult negotiations in Rome. I feel like difficult negotiations happen in Siberia or something. But in Rome, finally the passage in 1998. And let me just quickly go over, and let me also say, with its 60th ratification in 2002, the International Criminal Court became operational, and that's why last year in 2012, there's quite a bit of celebrations for the 10th anniversary of the court's operations. Now, let me just quickly give an overview of the court itself, and then I'll again go right into us-icc relations. Now, the court has 3 main organs: the Office of the Prosecutor, the Registry. And the Registry handles defense and victims issues, not to mention everything conceivably possible a court would need. And the court itself has a very robust victims, reparations, and participation mechanisms. And then there's also the presidency and the chambers, so the pretrial, the trial, and the appellate chambers. The court also has assembly state parties, which is its quasi-supervising, quasi-legislative body, which currently has 122 state parties, which are party to the court. And so that's the assembly state parties that meets annually. And so now the other things, the 2 last points I'll bring up about the court. One, the court is a court of last resort. By the principle of complementarity, the court, unlike its predecessors, does not have primacy jurisdiction within the jurisdictions that it has. So, for instance, IC2I, the Yugoslav court, had primacy over domestic courts. The ICC is quite different. It's only no matter how it gets jurisdiction over a case, it can only go forward if the local jurisdiction is unable or unwilling to prosecute, investigate, and prosecute. Now, lastly I'll talk about is triggers. There's 3 main triggers, and I wrote down how each of those came forward. There's a state or self-referrals, where a state party or non-state party can refer itself or another state party to the court. And that to date has been the DRC, Democratic Republic of Congo, Central African Republic, Uganda, Mali, and Cote d'Ivoire, which is actually a non-state party that referred itself to the court. Now, the ICC prosecutor can unilaterally investigate and prosecute in state parties, and he or she is supervised by a panel of pretrial judges. And that to date is only one jurisdiction, one of its situations, and that's Kenya. Now, lastly, there's the UN Security Council. By resolution, can refer cases to the ICC, and that today is Sudan and Libya. Now, because I oftentimes talk too long, I'm going to quickly go through us-ICC relations. Now, during the negotiations in pre-Rome, the U.S. has quite a bit of robust participation, large delegations that met during the various negotiations. And today, many critical aspects of the Rome Statute, which again is the foundational treaty of the ICC, were the basis of American proposals. Now, so unfortunately, or I won't even say that with Ambassador here, we did not vote in favor of the Rome Statute. However, we did sign it, and the last day was open under President Clinton. And now I'll transition, and quite likely I'll say that the Bush's first term was quite an aggressive, different stance towards the court. What is colloquially said, we unsigned the treaty, where we told the UN that we did not feel we had any obligations arising of our signature. And we had some legislative passage of a few legislations that I will mention now. The American Service Member Protection Act, which prohibited certain assistance to the court, aside for presidential waivers, and then the 2000-2001 Foreign Relations Authorization Act, which prevents U.S. funds from directly going to the court. Now, the relationship with the court certainly warmed up in the second term of Bush administration. The American Service Member Protection Act, quite a bit of that was amended because of unintended consequences. And also, what I failed to mention was our bilateral immunity and non-surrender agreements that we would go around the world negotiating with countries directly. That campaign really came to a stop in the second term of Bush. Additionally, we abstained from the UN Security Council vote for the referral of Sudan to the court. Now, I'll quickly go over the Obama administration because I don't want to take any of Ambassador Rapp's thunder. But really, there was a continuation of some of the policies under Bush where we were supporting the court in kind on particular cases. Additionally, we started sending delegations for the first time to the Assembly State Parties meeting, which Ambassador Rapp and Harold Koh and others were attending since 2009. We also took part in Kampala Review Conference in 2010, which was a very important moment in the court's development. We voted in favor and advocated in favor of the Libya referral, the UN Security Council's referral of Libya to the ICC. And then lastly, I'll say about the bipartisan expansion of the Rewards for Justice program, which I know the Ambassador will go in more in depth. So with that, I will now introduce, which we, again, are so thrilled that you're here, Ambassador Rapp, and a quick bio of Ambassador Rapp. Previous to his post as Ambassador for Global Criminal Justice at State, he was the Chief Prosecutor at the Special Court for Sierra Leone. There, again, was highlighted by his prosecution of Charles Taylor, which ended up being the first former head of state to be held accountable for his crimes since Nuremberg. Also, in many of his cases under his tutelage there was the forced marriage and sexual slavery was recognized as international crimes, and then additionally, the recruitment and use of child soldiers. Prior to that, he was a trial attorney and chief of prosecution at the International Criminal Tribunal for Rwanda, where he prosecuted the first case ever of public and direct incitement of genocide. And then prior to that, he was trial attorney for the Northern District of Iowa. So with that, let's give Ambassador Rapp a warm welcome.
Thank you very much, Kip, for that generous introduction, and also for going over some of these items so I can be brief, though I often tend to go on and on these issues because I'm so excited.
I encourage the on and on.
about what's happening in the field of international criminal justice. But I do want to salute the ABA and its program, and I want to talk about that a little bit later, but what the American Bar Association is doing with the ICC, which they can do as a private organization to strengthen the advocacy, strengthen the skills, to make sure that these cases involving some of the most important crimes, certainly the most serious crimes known to humankind, and some of the highest level of accused persons, that these are well tried, so that people are guilty, that they're found guilty, if they're innocent, that they're found not guilty. To talk about the U.S. and this project, I share with you the need to kind of go back to Nuremberg. because this demonstrates that this has been an area of United States leadership, global leadership, and the United States made the decision, the President Truman, to send a sitting member of the Supreme Court of the United States, one of the most distinguished persons that ever served on that court, Robert Jackson, former Attorney General of the U.S., to lead the Nuremberg prosecutions at the great trial of the 22 Nazi leaders in 45 and 46. And anyone who's interested in this area really needs to go and read Justice Jackson's opening and closing.
Exactly.
Some of the most eloquent expressions of what this project is all about. But the part that always stays with me in having done these high-level cases is what he said and what's presented as the second paragraph of his opening, that the common sense of mankind demands that the law shall not stop with the punishment of petty crimes by little people. It must reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which touch every home. And that's what we did at Nuremberg in holding people like Goering and Ribbentrop and Hess and others to account. It wasn't possible to do that during the period of the Cold War. There wasn't the kind of international consensus that was needed. And it was after the end of the Cold War and after the horrible atrocities with more than 100,000 innocent civilians killed in the former Yugoslavia, then a year later, 800,000 murdered in only 100 days in Rwanda, that the international community, under our leadership, with Madeleine Albright saying as the resolution passed just 20 years ago last month, that she heard the echoes of Nuremberg in the chambers of the Security Council. The Council, under Chapter 7, established these tribunals to try those who bore responsibility for genocide, war crimes and crimes against humanity in the former Yugoslavia since '91, and then the following year in the Rwanda genocide. And of course, we continued that leadership with the Special Court for Sierra Leone and other courts that we worked to set up and fund to ensure that powerful individuals who had made the decision to commit atrocities, not to kill civilians by mistake, but to intentionally target men, women, and children as part of the conflict, and sometimes not even in the context of a conflict, that there would be accountability for these great crimes. Our approach from an American standpoint, which is very consistent with this principle of complementarity that's part of the ICC, and this is something, frankly, that at Rome we pushed for, was that international justice has a role when it's not possible at the national level. When you had such a destruction of the national system that you can't have it, at least you can't have it very quickly at the national level, or where you have no will, or where there's no real ability to do a fair process. And so, even though those courts, like the tribunals that were established in the 90s, had primacy over the national system, quickly we worked on an arrangement that would ensure that lower-level offenders and others would be tried in the national systems. And so that's been part of a key part of, let's do the cases at the national level that need to be done there, that involve top leadership or when there's no will or capacity, but let's try to do as much as we can at the national level. That's, of course, formally recognized in the Rome Statute, where the Rome Statute doesn't get involved, where the prosecutor doesn't get involved unless there's no will or capacity at the national level. And each of the cases that the ICC has taken so far have been not situations where the national, at the time that those cases came to the ICC, nothing, zero, zip, was happening at the national level. Maybe some prospect in the future that something would occur. Since then, there may have been efforts to build courts that would take lower level individuals, but these were situations that cried out for justice, and that's obviously something we want to see. I mean, when women are being raped, when other innocents are being murdered and mutilated in the DRC, or through the predations of the Lord's Resistance Army in Uganda or elsewhere in Central Africa, these are situations that cry out for justice, and we want to see it happen. And if it weren't for the ICC, we'd probably be talking about establishing a one-off court for these situations. And so the United States, looking from the outside at the ICC, says, well, here's an institution, frankly others are paying for it, that's prepared to step into these situations and to do the work that we've been a leader in. And so naturally, I think Americans have frankly, both political parties say, you know, when you're dealing with the Coney, when you're dealing with rape in the Congo, let's go. Let's do what we can to assist this court. You've mentioned the ways in which we've engaged in this administration, and there were, just to go back to deal with them quite specifically. One, in the period between 2002 and 2009, the United States had not participated, even as an observer, in any of the assemblies or conferences of the ICC. Now, Russia and China, by the way, did it. Russia signed the treaty like we did and didn't ratify it. China didn't sign and didn't ratify, but because both countries, like we were present at Rome, were entitled to participate and signed the final act, not the statute, but signed essentially the minutes at the end of the meeting, were entitled to participate as observers, which means you can give a speech to the whole group, you can participate in debate after the others, but you can engage. And we hadn't done that between 2002 and 2008. And as a result, some things may have happened on things like the crime of aggression, et cetera, that we might have preferred they would have done a little differently. But in 2009, in this administration, we made the decision we need to go as observers and participate actively. And so since 2009, and 4 successive sessions of the Assembly of State Parties, annual event, and then at the review conference in Kampala, we've gone, and I've co-chaired our delegation together with the legal advisor, Harold Coe, who's in that position, as people know, until early February of this year. And I think we've been able, by participating in discussions and then by engaging with the officers of the court, to make sure that our point of view and our interests are well represented, and we can talk about that. Keeping in mind that one of our key issues is that we want to have accountability for mass atrocities. I mean, as President Obama said in the National Security Strategy of 2010, you know, the prevention of mass atrocities is a core national security interest of the United States and a core moral responsibility. He goes on to say, and a key way that we prevent them is by holding people to account for those that have been committed already, and sending the message loud and clear that if you commit these horrendous crimes, the day will come when you will face justice. As he said in his atrocity prevention, the announcement of that initiative, you know, we want to put people on notice and legitimate notice that they're going to face consequences. So, in terms of our engagement then with the ICC, we also looked at our law, and we have to comply with the precise letter of the law. You mentioned the American Service Members Protection Act, which passed in 2002. It did initially require the United States to negotiate non-surrender agreements with countries, unless they were NATO allies or major non-NATO allies, then that we would cut off all sort of military contact, cooperation, assistance with them. And in about 2006, Condoleezza Rice said this was counterproductive to our coalition building efforts in the world, and so the Bush administration asked for the repeal of that section. But generally, the American Service Members Protection Act continues to prohibit us from doing certain very specific things with the ICC. But interestingly, and people who know Congress know how you pass bills that sound like American Service Members Protection Act, that sounds very good, and who could vote against that? But Senator Dodd presented an amendment that eventually was unanimously adopted in the Senate, adopted in the House, that said nothing in this bill, nothing in this act, will prevent the United States from assisting in the case of a non-citizen, such as Osama bin Laden, Saddam Hussein, Slobodan Milosevic, or any other person charged with war crimes, crimes against humanity, and genocide. And apparently does provide us with an ability, if we have a case, to assist the ICC. Now, there's another law that passed in 2001 in an authorization bill that prohibits the United States from providing direct funding. And though this is not the actual opinion of the Office of Legal Counsel, is not public, we've talked about it, that we looked at this in early 2010 and determined based upon the law that we could assist, looking at these two laws, case by case, in kind, but not in cash. And so we then, as we announced in our various speeches at the Assembly of State Parties, said that we would engage with the prosecutor and the registrar and other court authorities, looking for ways that we could provide in-kind assistance to help the court. And looking at where these situations are, we made the decision that, frankly, in each of these situations, there's a need for justice. We'd like to see the court succeed in charging the people that are truly responsible and then holding them account in fair proceedings, while working with the national system to strengthen the system so that it can take over or at least do the cases that can't be done. So that's basically been our approach through an interagency process that's operated by consensus. I won't get into the specifics of what kind of requests we've accepted. Obviously, you've seen us provide political and diplomatic support to the court in various situations and in the enforcement of its warrants. But you look at things like in-kind support, and that does permit ways that if you have situations with victims, witnesses, investigations, etc., that you might be able to find a way to provide some in-kind help to the court in an appropriate way that could help it do its job. And so when the court wants to consider one of these things, we have a process to reflect on it and seeing what we can do. Now, one of the areas, and coming up here to the Hill, is the first opportunity I've had since the legislation passed, where we've really been able to, I think, step out, and this was based upon the legislation that passed unanimously in both houses. In the Senate, it was on the floor while we dealt with every single objection to it, and in the end went through unanimously, and then passed the House on the night of January 1st, and the budget bill passed and signed by the President in mid-January. It specifically provides in it that the law is passed consistent with the American Service Members Protection Act, and it is a form of in-kind assistance to the court. It's maybe assistance to others that benefits the court in kind, and that's the expansion of our Rewards for Justice program, at least our part of which is called War Crimes Rewards Program. Understand the U.S. has some other Rewards for Justice programs on counterterrorism, and narcotics, now expanded to include transnational organized crime, generally for cases that could be prosecuted in our national courts. We have, for more than a dozen years, had another program, which has been administered by my office, that provides rewards of up to $5 million for information leading to the arrest and transfer of persons wanted by the International Criminal Tribunal for the former Yugoslavia or for Rwanda. All of those that were charged by those courts. And those, we spent a lot of effort, and we did, you see the posters that are still in my office, with X's over the ones that we got arrested. But, we publicized these heavily. I've still got the matchbooks in the CS of Hadjic and Mladic in the former Yugoslavia, and we still, have some 9 fugitives of the ICTR. But we've done a lot to promote it, and frankly, as I told the Congress when I was here testifying in the House Foreign Affairs Committee before Senator Rice's subcommittee last year when this legislation was considered, in the preceding 2.5 years before that, I had personally been involved in paying rewards in 14 different cases. Now, it's up to $5 million. The largest we paid was $2 million. It depended upon the value of the information, the risk taken by the informant, the level of the perpetrator. But this was a law that was pretty soon going to become kind of obsolete because they got all 161 at the Yugoslavia court. They're down to only 9 at the Rwanda court. And Congress, working with us, and particularly want to salute the work of Congressman Rice and current boss, Senator Kerry, who were the chief sponsors in their respective houses that brought this bill forward. But basically created a situation where now we can pay rewards for any international hybrid or mixed court if the Secretary, on notice to the Congress, designates these individuals as cases upon which we can pay rewards. And after this was passed, the Secretary did proceed to the designation of 5 individuals, which were Bosco and Uganda. And before we announced the program on April 3rd, and by the way, it had already been out that he was likely to be listed, and it was in a blog in the Congo, that he could be potentially subject to the reward, and people were ringing up saying, where can we take Bosco, et cetera. Situation in a lot of ways grew too hot for him. That was one of them. Turned himself into our embassy in Kigali on the 18th of March, and then one of the ways that we contributed and assisted the court in kind without any cost,
Yeah.
was to work with the ICC to get him transferred to The Hague. But the other four, we made the formal public announcement, the Secretary and I, on April 3rd, was Sylvestre Muruchimura, a longtime leader of the FDLR, the Force Démocratique pour la Libération du Rwanda. That's on the other side of the conflict from Bosco's people, is the leader of the group that's generally viewed as representing the remnant of the genocidal army in Interahamwe of Rwanda, and has continued to commit allegedly the worst atrocities being committed in the eastern DRC. And actually is kind of a magnet for other groups, because other groups rise up to fight them and then begin themselves to prey on the rest of the population. So if one could knock out the FDLR, you could knock out a lot of reasons for intervention in the Congo and for other armed groups. So he's been only recently charged by the ICC, and we included him on the list and believe that the program could be very valuable in providing intelligence that could be used to locate him, and particularly now that the mandate of the MONUSCO, of the UN peacekeeping force, includes an intervention brigade and efforts to end impunity and restore security, etc. There may be opportunities to use that intelligence in a way that could bring him to justice and profoundly weaken the FDLR and increase the possibility of a lasting peace in the eastern DRC. The other three that we charged were more famous and led by Joseph Kony, who's been under charge by the ICC now for, I think, 8 years, but has been driven out of northern Uganda and has continued to prey on the populations of the WICC, the CAR, and to some extent South Sudan. And we have already an operation, an advisory operation with regional militaries that's helping in the effort to locate him and bring him to justice. But this program of providing rewards is strongly supported by AFRICOM and by the Department of Defense, because they see it as a way that will, already we have an active program to encourage desertions. This will encourage desertions with information. People will come out and have information that can help us know where Kony is or where he's going. And so both of those, in both of those situations, in the DRC and in Uganda, we've announced these rewards. Just in terms of the law as it stands right now, the kind of things we can't do. I know the EU has been supporting your ABA program. Or maybe it's going to. You think it might? Maybe I shouldn't say it.
I didn't think you would put me on the spot right away, but yes, it is, of course.
Okay, and so, and of course private donors are. But our approach is in terms of the US government, unless Congress were to make this a special provision, et cetera, is that things that benefit the ICC as a whole, as opposed to the prosecution of a specific case, would, a very plain reading of the Dodd Amendment and the ASPA says, in cases involving specific individuals. So something that helps the court become more effective and could help them with another kind of case that maybe we don't support is something that I think our law would probably restrict. On the other hand, if you were training people on how to deal with mass graves in northern Mali or something like that, or a specific situation, then it might be different. But that's an example of the restriction we have. And as I say, the direct funding is something, as I say, that comes not from ASPA, but from another provision. And people can debate that. There's sometimes that funding or putting money out there, you could actually get more for it than you can by doing it in kind. But that's something that Congress will have to consider in the future. As it stands, we're able to work within the legal regime that we have there to provide some I think, good help to the court. Just in terms of the situations, briefly, that the ICC has become involved in, and I know there's controversy about how they pick the cases, but you've noted there's only certain ways the ICC can get involved. And one, you have to have these certain triggers, but there are only certain places in which this can be triggered. You have to have a crime committed by a national of one of those 122 countries, or you have to have a crime on the territory of 122 countries. And some of them are places that haven't had crimes committed in a long time, like Norway or something. You know, you're not, or Liechtenstein, et cetera. So, but a great many countries, I mean, 33 countries in Africa have ratified. Every country in South America, all European countries, et cetera, are in the ICC. But you have to have that territorial thing. And then, of course, the prosecutor can't go in there unless the state asks him to, or unless he goes to the judges and gets permission. There is this second one, this other way, which a state that's outside the ICC can send itself in, which is what Cote d'Ivoire did. Still, then they have to get, the prosecutor has to get permission, but it's really them that is sending it. And since Cote d'Ivoire Ivory Coast sent itself to the ICC, it's also ratified the statute. And then you've got situations that can come to it when the Security Council refers. And when the Security Council refers under Chapter 7, that can go anywhere.
Universal.
Of course, but only anywhere post-2002, because the statute can't be applied retroactively before July 1st, 2002. So it can't go back and deal with Cambodia's or Bangladesh or crimes, mostly crimes in Liberia, these kinds of things are outside the ECC, even if the Security Council were revoked to 15-0 or the minimum 9 votes affirmative and no vetoes. So that's, but the cases in which the ICC has gotten involved, 6 of them involve situations of states that are now in the ICC. And of those, 5 of them, including Cote d'Ivoire, explicitly sent the case to the ICC. Uganda did, the DRC did, CAR did, et cetera. Cote d'Ivoire did, Mali has most recently. Asked them, please, prosecutor, come here. So to criticize and say, the ICC made a mistake is to criticize those governments that said, we need you, we don't have the capacity ourselves to do this at this point. Kenya was a case in which their national commission, the WICC commission, called for accountability, called for the establishment of a special tribunal, which frankly, I would love. That's what we prefer. Bush administration, we would prefer it too, as Secretary Clinton said when she went to Kenya in August of 2009, but they didn't move it. They didn't move the legislation. Couldn't get a quorum on the days that it came up in Parliament. And so the WICC Commission had said, if the ICC, if the tribunal isn't created, then the evidence should go to the ICC. And in fact, the Prime Minister and the President and the Justice Minister invited the prosecutor to say, prosecutor, you did this. They said, we'll refer it to you now. At the last minute, they said, well, we're not going to refer it to you, but we'll cooperate. You can go ahead with this evidence and open your case. So it was effectively a situation where the country brought the ICC in and where it was explicitly recommended by its independent commission. And of course, the other 2 situations, Darfur and Libya, are situations where the country itself, Sudan under Omar al-Bashir, and at the time of the referral, Libya under Muammar Gaddafi, were alleged to have committed horrendous crimes. There was no accountability whatsoever. Indeed, they were encouraging people to commit those crimes. And therefore, there was no ability to do it, and there were votes in the Security Council to refer them. Even Russia voted for the Darfur referral. We abstained. And in the case of Libya, all 15 members of the Security Council, all African countries, and Russia and China voted for it. So that's how the ICC has gotten into these 8 situations. And when people say it's unfair that they're all there, it's unfair to bring up that criticism. On the other hand, the ICC does have other preliminary examination situations where there may have been crimes, where it's watching to see what the national system is doing. Another of those is in Africa and Guinea because of the stadium violence where 100 or more people were murdered and 100 women were raped during a political rally in September of 2009. The ICC is standing back and hoping that the national system will do it. Colombia, with its peace and justice process, is also one in which the ICC has been actively engaged in saying, well, they're doing it. Should we jump in here when the country's doing it themselves? There are other situations, but those are the ones where it's probably the most active in terms of preliminary examination. And it can have an effect. I mean, that was our dream of the ICC, that if you have the sort of 900-pound gorilla off of incentive, countries would say, well, we don't want to send it registered. Hey, let's do it ourselves. And you could maybe get some, that this is is a form of complementarity. Maybe it's the negative complementarity. It's the pressure. Positive complementarity is when you go to work with a carrot, with the money and assistance to strengthen the national systems. So, but in any case, we do have these situations. I mean, one can talk briefly about them. Obviously, in Uganda, there were originally 5 ICC suspects charged. Joseph Kony was the leader of that group. Now, 2 of those people are since dead. He may have had a hand in that. But there are 3 that remain: Joseph Kony, Odhiambo, and Dominic Ongwen. And obviously, none of those individuals have yet been brought to justice, and it's critically important that they do be brought to justice. Meanwhile, Uganda has developed its own high court, or its own a division, the International Crimes Division, and is prepared to prosecute others. Has one case. There's an issue that's before its appellate courts right now. It may soon have another where it's prosecuting some at the national level who are more mid-level, high level, but not quite at the level of Kony and Odhiambo. The DRC is where the most action has been, with a total of 4 individuals who are presently who've been brought to justice there. 2, 3, 4. Making sure I'm not missing anybody, but we've got obviously Lubanga, who was convicted, Gajolo Chui, who was acquitted, his co-defendant Katanga, whose case is continuing there, and then there's the case of Bosco Ntaganda. There was another case, Kalinzira Calixt, an FDLR leader in Europe, who the judges declined to confirm the case on. Even though he was in custody for a period and had he's since been released. So, and of course, we've got the Sylvestre Mudachimura indictment, the arrest warrant that's out there. And there's the possibility, the prosecutor has said, that further charges could be filed in the DRC. But of course, there's a lot of horrendous warlords, et cetera, in the DRC that have been involved in a lot of crimes that the ICC can't get to be frank. And one of our high priorities is to strengthen the common release system and perhaps even to establish a mixed court in the Commonwealth to go after some of these cases, because the ICC certainly can't do it all, but there's a need for strong, effective, and independent judicial processes. The Central African Republic, the former vice president of the DRC, Jean-Pierre Bemba, allegedly sent his militia into the DRC in support of one faction in a contest between 2 military leaders, and allegedly committed mass atrocities. That trial is ongoing, very close to its conclusion. Sudan, of course, everyone's familiar with the arrest warrant against Omar al-Bashir. That occurred only after 2 leaders, allegedly in the Darfur crimes, had been charged by the ICC. One, a minister, Haroun, and another, a Janjaweed leader, a guy named al-Bashir. Interestingly, those arrest warrants have now been on file for almost 6 years without any cooperation. Indeed, if they had been brought in, there might have been a less chance of the Bashir indictment. There would have been some cooperation or some response on the national government's part. Interestingly, I saw a report from Human Rights Watch that al-Qashai, this alleged Janjaweed leader in Darfur in the crimes back in 2003-2004, is alleged to be leading groups into violations against civilians in April of 2013 in central Darfur. You know, one of the things as an 8-year U.S. attorney, we always used to talk about, the effect of deterrence, and, we debated about general deterrence, whether you could deter crimes by prosecuting others and people would gain the message. But I was always a strong believer in special deterrence, which is one of the ways you deter crimes is by locking up the guy who's committing the crime so he can't do it again. So that works, but it doesn't work when you don't get the guy arrested. So you've at least got allegations of his involvement. Since then, Bashir himself has been under arrest warrant since March of 2009, and the president of the country, and recently the defense minister has been charged. There were 3 individuals who were on the rebel side that were charged by the ICC. One of them they found insufficient evidence on. 2 were set for trial. They were given bond and allowed to go back, and one of them was recently killed. So sometimes getting out on bond is not the safest thing to do. But the other of those 3 individuals is scheduled to have a trial early next year. They're alleged to have attacked African Union peacekeepers who they believe were working with the Sudanese army, at least that's their defense. But the ICC is often wants to prosecute both sides in these situations of conflict, just as we do in the Special Court for Sierra Leone, or as the ICTY prosecutor did. Beyond that, obviously, we have the Kenya case, originally with 3 individuals on each side of the alleged post-election violence. On each side, one of those cases failed to confirmation. There weren't arrests. Those individuals have voluntarily appeared under summons. 2 on each side. One of those 2 cases was withdrawn. Prosecutors saying that there had been efforts to interfere with the witnesses to such an extent that the case had been knocked out and she couldn't move forward. But the other 2 cases, one involving the individual, now President Uhuru Kenyatta, alleged to be responsible for the violence on one side in the post-election period in 2007-2008. On the other side, his current vice president, the deputy president, William Ruto, and a broadcaster for Sang Radio, for Joseph Sang, for Cass Radio, are also charged. And those trials, the Ruto case is now scheduled to go forward in September. Will probably be a lot of discussion about the Kenya case and what's happening with it, but as far as Kenya is concerned, the ICC pretrial chamber, in setting the Ruto case for September, asked that the judges of the whole ICC and the president consider holding part of the trial in the region, either in Tanzania, presumably at the Arusha court, where I used to work at the International Criminal Tribunal for Rwanda, which is now basically closed its work, and so courtrooms are available, or in Nairobi. Perhaps not all of the cases, because some of the victims and some of the insider witnesses believe that there's a security threat to testify. But that decision is in the hands of the plenary of judges and the president of the court. But obviously, it's to the extent you can bring justice closer to the scene of the crime and to the affected community, that's something which we'll see how the court relates to it, but if it's possible, it's something that I think would be a good sign. And then we have Cote d'Ivoire and Mali. Well, I'll get to Libya last. Cote d'Ivoire sent its situation to the court at the moment, and don't want to go into too much detail, but there's the case of Laurent Gbagbo, the president, who was surrendered to the court, is alleged to be responsible for the violence committed by forces under his control, or forces that he supported during the post-election period between November of 2010 and April of 2011. The pretrial chamber has asked that additional evidence be presented on certain points. 2-1 vote, one judge saying it was enough, another judge saying it needs some more. So that's still on its way. Mali referred itself and the prosecutor, after consulting with the countries in ECOWAS and the African Union, decided that she would accept that referral. There are no indictments yet. Prosecutor is looking at certain incidents of violence that occurred in the north during the time that the extremists took over that part of the country, potentially also at the attack on the tombs, the Sufi tombs and religious objects and library in Timbuktu, but has also given warning to people on the other side of the conflict, including the Malian army, that if they commit atrocities, they can face consequences. In the Libya situation, as everyone knows, the court relatively quickly, even before the end of the Libya conflict, returned arrest warrants for Muammar Gaddafi, for his son Saif Gaddafi, and for the head of the intelligence services, al-Sanusi. Of course, Muammar Gaddafi was killed on the last days of the conflict. Libya, it's post-Gaddafi government, but it's sort of going to control those individuals on its own. And because it was a Security Council referral, the prosecutor did obtain arrest warrants in that case, and those stand unless Libya can show that it's able and willing to take on these cases, and specifically that it can be done in a genuine process. And Libya filed an application in the SAFE case, the individual they had sooner. The ICC has recently ruled that because the national government doesn't have physical control of SAFE, he's still in control of his intent militia. And there are a few other issues that they found before that they didn't get involved in the process of procedures, but they were concerned about their ability to guarantee a genuine process. The Sanusi case is still pending now in terms of Libya. Libya has also applied for that case to be deferred back to Libya. Understand Libya has not appealed the decision of the pre-trial chamber and has asked that be suspended. One suspects that that will now be suspended for a period of time, and if Libya now comes forward and shows that it's doing the process on SAFE, that is a genuine one, that's something that we may well consider. We'll have the same sort of issues coming up in the Sanusi case, but Sanusi, who was arrested in Mauritania and returned from Mauritania to Libya, is in national custody, so there's not the same issue there. Moreover, the allegations against Sanusi by the Libyan authorities involve crimes committed over the course of a couple decades. We've had suspicion of his involvement in Panama 3, and there's a lot of bad acts that have been attributed to him beyond simply the acts during the post-February 2011 period. So the Sanusi presents a somewhat different case than temporal issue. But and understand that if a country wants to prosecute its own individual for other crimes that are outside the ICC, but it's willing to say that it will, at an appropriate time, turn the person over to the ICC, then the ICC is prepared to negotiate and determine the sequence of who will go first and how to coordinate that process. Anyway, went on as I feared far too long, but that's a summary of where we see the ICC today. Understand that we're, as I said earlier, very interested in making sure that people who commit these horrendous crimes are held to account, preferably at a national level. But if it's not possible there, then at the international level, the ICC can be useful in this regard. We're not ourselves yet making a decision to join the court. The United States takes a very long time before it goes into international conventions. It took 40 years on the Genocide Convention. We've seen recently the Senate debate on the Disabilities Convention, with the challenge of having 67 votes in the Senate. And so we'll be watching the ICC, I think, for a long time before a decision were made about whether the administration would have us go in it. But obviously, given our commitment to accountability, we want to see this institution do the right thing, to focus on the worst atrocities and find ways that we can help it be effective in the interests of the victims of these horrendous situations and the interests of potential future victims by sending a signal that if people commit these crimes in the future, they'll be brought to account. So thank you for the time, and we've got until 3:30 or so to do questions.
Yeah, we'll do it. So, thank you first of all for
Okay.
that. Certainly, we can go in depth in any one of those situation countries, and so thank you for giving us actually quite a bit of detail in each one. I'll have two follow-up questions, and then open this up to the audience, because again, this is an opportunity to ask the ambassador questions that may be of interest to you. One thing I'll just start with is the suggested next steps in the US-ICC relations. As you mentioned, that in Nuremberg, when Churchill and Stalin were arguing about how many summary executions there would be, it was the U.S. through our leadership that we brought this idea of due process and the rule of law. And additionally, as you rightly pointed out, the IC2I 20 years later is seen as such a success, but its first 10 years were not so much that way. That it took quite a bit of financial, human resources, logistical resources that I know you at the Special Court for Sierra Leone received as well, that it takes quite a bit to get these international institutions up and running and working effectively, efficiently. And so, even big or small, I would just, in your mind, again, this is just mere suggestions, what would be ideal next steps in the US-ICC relations? Although, putting aside the ASPA and those things, but sort of maybe Senate resolutions, because there are some Senate resolution, non-binding ones about supporting their caseload, things of that nature.
Yeah, now, again, obviously, you know, when I used to be a prosecutor. The great thing about being a prosecutor is you take this oath that you'll never take instructions from any government or international organization. I mean, as an international prosecutor, and of course, as a U.S. ambassador at large or an official of the U.S. government, I take instructions every day. So I don't speak for myself and what I'd like to, what I hope for, but to talk about the things that are realistic and could be looked at without saying that we necessarily cross those particular bridges yet. And these, but you know, people can, I think, pretty clearly imagine that there could be ways that we could strengthen the ICC's investigative capacity. What I learned in Rwanda, well, I learned as a prosecutor when I was U.S. attorney in Iowa. You know, you always need about twice as much evidence as you think you need, because there's always going to be difficulties and challenges in the case, and particularly at the international level, where you've got people who are brought from different cultures, who are under enormous pressures, particularly people that are testifying perhaps against their own clan, their own ethnicity, their own religion. Those being, of course, the most vital witnesses, because they're the ones that are going to know what the alleged perpetrator did. The innocent victim may not recognize these people that are coming after them. And so, you know, it is an immense challenge to investigate cases, and then to investigate those at high-level individuals, where you have to link the crime on the spot, where people are hacked to death or murdered or raped, to a leader that's some distance away. And of course, an international court is not about prosecuting the guy with a machete. It's about prosecuting the big shot. And so, and big shots usually, I mean, Hitler didn't even write out orders to say, you know, kill all the Jews or anything like that. And there were ways potentially proven that. But, you know, putting those links together are very challenging, and that takes very specialized kind of investigative skills. And then advocacy, the skills and ability to put on, in a sensitive way, witnesses, and to evaluate whether the person you're talking to is you know, somewhat political agenda or financial agenda, and that's why they're coming forth, as opposed to being able to testify to the truth. And the ICC has the benefit of people that work in prior tribunals, but it doesn't, it can't take a lot of Americans. It can hire Americans, but naturally the Assembly of States Parties that's paying the bills does have a provision saying, you know, the preference is for state parties. And so you don't get a lot of people. And if you go to these other international courts, go to the ICTY, you look at who the sort of front four are, you know, in terms of who the tough prosecutors are, the Harmons or the Teagers, Brenda Hollis, who I brought to the Taylor team, or other people that are there. They've been the key, really successful sorts of prosecutors at the international level. So this, the ability to provide skills training, which you're doing, but even the ability, and this has to be done carefully, there's nothing in our law that would necessarily prohibit Americans from being temporarily detailed to the court. That may not be financially easy. And the ICC may not like the perception that we're trying to take things over when we remember. Yep. But to the extent we can do it with other countries, because at the moment, I mean, the ICC has fewer than 60 investigators. I mean, one of the challenges right now, a lot of people talk about Syria, and of course Syria is not going to the ICC because the Russians have said yes and no veto. So even though 80,000 civilians have been brutally murdered, and children are being knifed, and hospitals are being bombed, and horrible weapons are being used, you can't take it to the ICC. But if it went to the ICC, just imagine all those crime scenes, all those mass graves, all of those situations. You know, that is an enormous amount of work. Who would do that? Now, at the moment, we're supporting things like the Syrian Justice and Accountability Center. We're supporting which is working with Syrians to gather the evidence and build files. There's a commission of inquiry, which is doing things, they're not really doing things on a criminal law basis or on a human rights law basis. But, the point is that there could be ways in which the United States could participate appropriately in partnership with other countries on a case-by-case basis to go in and help. It's something to look at, but and certainly we're in places where we make clearly the decision that this is a place where accountability is critical, and we're not in there for political reasons. We're in there because we can provide the skills and make sure that the cases are developed to a high standard. That's I think one area that I think we want to look at in the future. I'm not saying we're prepared to say yes, that's an interagency decision, of course, but that's something that fits within the current law apparently, because it does permit any kind of system.
Thanks for that. I'll cut my question short because, again, it's not for me, and this is for everyone here. So let's open it up to the audience for questions for the ambassador. And you don't have to all go at once. Go ahead, Sarah.
Hi, Ambassador Rapp. Sarah Craig with the Open Society Foundation. I was just in your old stomping ground in Arusha, Tanzania last week, and we talked about the possibility of extending the jurisdiction of the African court to include criminal matters. And, obviously that wouldn't be retroactive, so this is more a forward-looking question, but I'm wondering if you can comment on how you think that might play out in light of really the political nature of the ICC around the African Union at the moment. And maybe just, if you'll allow me, I
Sure.
think it's important to remember that the African Union was the one that appointed Kofi Annan, and Kofi Annan is the one who suggested that the Kenyan case go to the ICC. So I think we maybe easily forget that, with all the criticism that the AU has of the ICC, that this was not out of nowhere. And I think we're very concerned about what's happening in Kenya, the political manipulation, the witness intimidation. And, you mentioned that you have Kenyatta from one side, Ruto from the other side, that are now president and vice president. That just goes to show how political this has become. And, I don't know if you want to comment on that, but just as an aside, I think this is relevant to what happens with the African court and how this plays out in the country.
One thing I do want to say about the ICC in Kenya is that, I've said this before publicly, so I go ahead and repeat it. We just went through an election in Kenya, and obviously it ended up with Ruto and Kenyatta getting elected in the first round. I had to go to a runoff, but it was an election without violence. It was and even before 2007, there were a lot of elections that had had violence, and I think that's a reflection of a lot of positive things that have happened in Kenya. But I'm a prosecutor, and I believe that when the signal has been sent that if people commit these kinds of crimes, they're going to be hauled before a court, that it has an effect. And I do think that no one, even if they think maybe at the end of the day they can beat this, wants to be in the position of being charged by the ICC. And so I think the idea of inciting a bunch of people to run and kill, harass, violently the other side, the civilians of the other side, which had been what was happening in 2007, 2008, and it happened earlier. That kind of tactic was something that the fact the ICC was doing something and bringing it forward had a good effect. So whatever is happening in Kenya with cases, I think it's already been a good thing that they got involved. Now, as far as this African court is concerned, we start with our fundamental U.S. principle: best to have justice closest to the people and the affected communities, and that usually means the national system. And the national system is going to be there forever for those people, and if you need to do these big cases and there's a failure of will or capacity, but it's not so devastating that you can't work on it, then the answer is to work with that national system to help provide the capacity. And if you've got questions of will or independence, then the idea of having some international judges or prosecutors involved on a temporary basis, like in Bosnia, or we're talking about in Congo, et cetera, that's a way in which you can help strengthen the local people and also assure the victims that the person is not going to be against them because of the ethnicity. Now they've got a mix that includes internationals. etc. So that can make a far more effective process. So we very much want to see that kind of thing. Now the next question is, what about a regional court? Well, in principle, fine, but the challenge of anything on a regional level is you have to kind of create it from scratch. And we know the challenges of creating international courts from scratch. You don't have a national system to build on at all. And so, there already is a regional court in Africa. I mean, there are regional courts within the ECOWAS and SADC and East African communities, et cetera, with limited jurisdiction. But there's an African court for now a combined justice and human rights court.
Yep.
I think 5 countries have accepted its jurisdiction. But it is judges cost money, but it's a relatively inexpensive operation because it deals with cases that have already been decided at the national level, come to that court, and they have to hear an argument and write a decision. And, a Strasbourg court, an American court does, et cetera. But they don't have to deal with what a criminal court does, which means traveling out there and investigating, and then protecting the witnesses that you're talking about, and developing linkage evidence, and then getting cooperation and arrest, and then detaining those individuals in the international standard, and providing with the defense, and doing the prosecution, and doing, all of this complex process. I mean, the Africans-based Institute for Security Studies, which has offices in Addis and Pretoria and elsewhere, was, what's his name? We'll come to it in a moment, Duplessis. Is written, that the minimum cost of an African court, let's imagine maybe a third of the cost of an ICTY, 50 million or 60 million, would be more than the cost of all of the other African Union institutions supported by African Union members. There are other things that the Union may do, but they're receiving funds like that, and so on, things like that. So it's an enormous undertaking, and there are those that are concerned that this idea is presented as an idea for trying to get rid of the cases that are there right now. And as you know, it's only for the future. But there's a tendency to say, oh, we don't need that, we're going to have an African court. Well, before you take away a justice that's there in the ICC, as the ICC itself said in the Kenya case in the pretrial chamber decision on admissibility, there has to be a real case in which you're investigating the same individuals for the same crimes. And so this is something that people can look at, I think, for the long run, maybe. But first, I think, deal with the justice that's there, deal with the national systems, get the court for human rights set up, which so far I think 5 countries, only 5 countries have adopted the protocol for, 53 or 54 in the African Union. Those are steps that I think are important to take first. Also, the court wouldn't just deal with atrocity crimes, it would also deal with trafficking in persons, piracy, drug crimes, organized crime, corruption, lots of different things, which I think are, and unconstitutional change of government, concerns about coup d'etat, et cetera. So, which they haven't defined yet. So it's a project to consider and to work on, but I think the most valuable place on the continent would be to work at the national level to strengthen the judiciary and to mix potentially courts in places where the capacity isn't there now.
Well, and I would just add also that it fragments the international criminal justice mechanism that we're trying to build. And I think if there's too many complications of what court it goes to and as such, that it over. And then the last thing I always like to point out when people talk about Africa and ICC is that at the end of the day, yes, there is you can make an argument, and there is one, there's selective justice, but at the end of the day, there's still victims in Africa and victims in these situation countries. And I think the politics sometimes get away from the fact that there are people on the ground who suffer. Ambassador Graham?
Yeah. I'd just like to follow on the previous question and explore a little bit, if I could, the meaning of this, this part of the court's jurisdiction, that it can step in where there's not a will to prosecute it. Clearly in weak, let's say African states or elsewhere, Southeast Asia, wherever, weak states that have been largely destroyed by civil war, there can't be a will because there aren't functioning institutions. But is the court's jurisdiction limited to those situations, or, for example, just theoretically, I realize there's financial problems and political problems, but just theoretically, could, let's suppose there was a tremendous crime against humanity committed by Pakistani Taliban in the northwest provinces, where no courts, where there isn't any justice system because the state can't get there. Or Saddam Hussein, could he have been prosecuted? Iraq was seriously damaged by the war, but there still were courts, and they could, and they did try them, actually. And so would it be possible, theoretically speaking, for the court to intervene in such situations, or is it pretty much limited to Mali, Sierra Leone, Cambodia type of situations?
Well, first of all, do keep in mind that you know, there are whole regions where the number of ratifications is less,
Yeah.
and in South Asia, Bangladesh and Afghanistan are members, and so I mean, Malaysia may become a member going to Southeast Asia, Cambodia, Malaysia, or Cambodia and the Philippines are in. But you don't have a lot of, in the Middle East, only Jordan and then Tunisia's recently joined. And so you have a lot of areas where the ICC isn't, and it's only going to get involved if the Security Council sends it there. And of course, Sudan and Libya are very big countries, and the ICC did get those cases because of a consensus in the Security Council. Pakistan's not a member, Afghanistan is. But the court, before it could get in, the country, keep in mind the prosecutor can, in any of these situations where there's jurisdiction, you know, it's horrendous crime in the territory of a ratified state or committed by the national of a ratified state, he or she can go in, but has to get permission of the judges. And then the judge is going to ask a lot of questions. Is this grave enough? What's happening there? How are you going to be able to do it, et cetera, et cetera. So he has to go through, jump through a number of hoops to go there. More likely, the country itself could say, please help us in this situation, which is what Uganda did because of the Lord's Resistance Army, or the DRC did because of the violence in the East, et cetera. And so you could have the cases come in there. Then the prosecutor doesn't have to take them, but he or she doesn't have to go through any hoops, but it has an internal thing that said if a country sends a case, I mean, for instance, South Korea has sent a case against North Korea based upon the shelling of the island and the attack on the Cheonan PT boat, et cetera. Now, of course, the PT boat was sort of a military target, so even though it wasn't a good thing, in countries that are still technically at war, attacking a military target may be bad, but it may not be a war crime. And so, and then the question was the shelling, was that a war crime? And then was it sufficiently grave? I mean, you've got a case like Kenya with 1,200 dead, 300,000 displaced, and the judges voted 2-1 whether to take that out, et cetera. So you're not, the idea the ICC is going to get involved because of a dozen dead or something like that. They're going to say it's bad, but it's not so bad that it needs to go to the international level. So there are a number of factors that have to be borne out. But it does get back to this issue of capacity. You know, if there's no capacity, and you know, if there is an absence of capacity, then the prosecutor can go in and say, well, can we get some donors to go in there and help? I mean, the prosecutor may not be that active in this positive complementarity, but it's important that through the process that it could be a development tool, et cetera. There could be other ways to deal with it. And then you get into the will issue, and I understand that will is not, the analysis on will is like a 4-part test, and part of it is the sort of the will to run an impartial or fair process. Some countries, of course, have enormous will to hang the last regime. You know, there's no question they have a will to do it. Others don't want to, of course, want certain people to be prosecuted, and so it's this will to do an impartial thing. But theoretically, the ICC could get involved in these major situations, and but fundamentally, the reason that it can't often relates to the fact that those countries are outside the ICC and that they may have protectors on the Security Council that would prevent a case from coming to
But if Iraq was a party,
if Iraq had been a party Saddam potentially could have been prosecuted. The main problem there was July 1st of 2002 is the beginning of the ICC. And crimes like the attack of the Marsh Arabs, the Kurdish, the Anfal campaign, all those kinds of things predated that. So that was going to have to be done by a process other than the ICC. But it could, a situation like that could be at the ICC. And indeed, the Iraqi High Tribunal used the statute that was adopted during the provisional government period that was very much like an ICC statute.
Any questions back there?
My name is Nicole. I'm an intern in the Senate. And I was just wondering if you could speak about the somewhat conflicting nature of international case law regarding genocidal crimes. In their prosecution of the crime of genocide, the International Criminal Tribunal was somewhat contradictory. Like in the Firstick decision, the ICTY Appeals Chamber said that some genocide is a crime of crimes, but this view was kind of reversed by the ICTR and Karyshema and Riodana decision. I was wondering what's your take on genocide as a crime of crimes and the hierarchy of crimes in general, and the view that there is one?
Well, it's a complicated question. And first of all, the idea that one sets out to destroy a whole ethnic or religious or racial or national group in whole or significant part as such is obviously a horrendous sort of thing. But do keep in mind that sometimes there have been genocides. And we used to say, if you had that intent and you went out and killed the first 100 people, but you weren't able to finish, you could still be convicted of genocide if you had that intent. And so sometimes the actual numbers killed in a genocide may be less than others. Kip worked at the extraordinary chambers for the courts of Cambodia, and in Cambodia, if you go to Tuol Sleng and S21, I'm sure many people have done that. 15,000 people were brought in, tortured to make false confessions and implicate others, and only 7 people survived. But they were all persecuted. You look at their pictures, most of them are pro-Khmer Rouge. They look like Red Guards, etc. They were eating their own children to a large extent, but they were killing some others. That was not a genocide. That was a crime of massive persecution as a crime against humanity. Extermination of that group, or persecution on a political basis, etc. And the crime in Cambodia, there may have been a genocide of the Cham, the ethnic, religious, largely Muslims, and Muslims do not fit well in a system that was monolithic and atheistic the way that system was, and so they would get targeted. There's some question that maybe the killing of the Cham was genocidal, but that's only a very small percentage of the 2 million who died. So the worst crime in Cambodia, the crimes that cost the lives of 2 million, not genocide. And so saying that genocide is always the most serious crime, it depends upon the facts, and genocide has to be on a racial, ethnic, national, or religious basis. It can't be on a political basis, which is what often is happening. I mean, sometimes these things become ethnic or sectarian, like they are in Syria, but in Libya, for instance, it was the opponents that the regime that needed to be chased down house to house and moved to the closet, killed like rats. That is not a genocide. That's killing innocent civilians who are exercising their rights and doing it on a political basis. So there's a difference in that. You can't say that one is worse than others. I know my predecessor is the prosecutor of the Special Court for Syria and Ukraine, and we didn't have genocide in Syria. They didn't even put it in the statute. It wasn't religious. It wasn't ethnic. And I said, well, it can be worse than the genocide, and it can be. Finally, just in terms of the jurisprudence on genocide, because obviously in Rwanda, we had the court actually take eventually judicial notice that there had been a genocide in Rwanda, an intentional killing of the Tutsi ethnic group. In a very significant part, about 70% of the Tutsis living in Rwanda at that time were wiped out, and they were killing them on the day they were losing the war, and killing them at the border so they couldn't get out, etc. It was like a Holocaust in that respect. No question, it was a genocide. In Srebrenica, and only in Srebrenica so far, has the ICTY, the Yugoslavia Tribunal, found a genocide. And you will find Serbs who say, but they let all the women go. How could that be a genocide? But of course, they killed all men and boys, 7,000 or 8,000 in that particular valley. that was found to be significant enough, at least in the context of that area, that was genocidal, even though there were other safe areas where the men and boys were allowed to live that were at the time. So, but it was that basic sense that these people are Muslims, they are enemies, they will fight us no matter what, even though they're too young to pick up an arm, etc. We need to kill them now to keep them from growing up and becoming an enemy of ours. That was a kind of a genocidal intent to destroy them because they were Bosnian Muslims and a member of a group as such.
And your point's a good one, though. What you're discussing about Cambodia, one of our hardest problems, the outreach of the prosecution department there was to tell people that just because there wasn't a genocide there, that doesn't mean that the worst of the worst did not occur to you. And so that was certainly a kind of a nomenclature thing that we had to get over. But it's a very excellent point. Professor Fairley, and then there's one over here.
Ambassador, I have a primary question and then a bonus question.
Oh, boy.
You can ignore if you want to. What I'm most interested in hearing is what, other than ASPA, in your opinion, presents the greatest impediment at present to U.S. cooperation with the court. And if your answer is different, what presents the greatest impediment to U.S. membership, ultimately? And what might be done to ameliorate those? And should I give you that, and then maybe see if you want to hear the next question? It's not related, so.
Yeah, well, obviously, I don't think beyond this, the restriction on our ability to provide assistance, outside of cases on supportive sort of skills, there was something I don't think we can do now, and this issue of financing, I mean, in particular, we recently dealt with it and we haven't made a determination yet, but they have a victims trust fund, for instance, that has been providing fantastic work for victims in Uganda and DRC, and they've developed these programs for the children that have been child soldiers and sex slaves under Coney, et cetera, and working with partners. They've got 40 or more programs in northern Uganda. Now, we're doing other things in northern Uganda that are very positive. But it's a separate trust fund for victims, but it's an ICC trust fund for victims. One of the questions that's recently arisen in terms of responding to this kind of violence, could we help the trust fund? People say, well, it's ICC. We don't know. We're still exploring whether that's specific, whether that's in the ICC or outside the ICC. We could decide that it was entirely independent and we could finance it. But still, the fact that we have this restriction on any kind of funding, even sending them, $20,000 to help set up a program for treatment for girls that have been sex slaves. We may not be able to do that now because of our law. Right. We maybe send some money to a partner that would go in, and we'd use a lot of middlemen, and we'd use up a lot of the money that way, et cetera. So that's kind of a problem with where we stand right now. So as I say, we're trying to work within the law and find ways that we can do positive things. In terms of the main reason that the United States doesn't, people, I'm reminded, I'm going to digress for a moment, but I was talking to Natalie Pillay, who's the High Commissioner for Human Rights, who I've known for a long time. She was the presiding judge in the media trial, the trial where I convicted, or led the prosecution team that convicted the principals of RTLM radio for direct and public incitement to genocide. She's a great person. Been an ICC judge in between. And I was talking with her about, the U.S. and ratification of treaties, and noting, of course, that there were a number of international treaties the United States hadn't ratified, like the Convention on the Rights of the Child. And even our own Supreme Court recognized that there were only 2 countries in the world that hadn't ratified it, the United States and Somalia. And I'm still kind of run down this report. I've heard that the Transitional Federal Assembly of Somalia may have ratified the Convention on the Rights of the Child. I brought that up, and she turned to me and said, but you Americans protect the rights of the child so much better than a lot of the countries that have ratified it. And I said, well, you're getting close to understanding our American political culture. We have our own Bill of Rights, we have our own legal systems, we have our own regulations, we have our own ability to prosecute the Sergeant Bales of the world who may commit atrocities and kill innocent civilians, as he pleaded guilty to last week. We do these things ourselves, and we're very proud of it. And Americans really have to be sold on the idea that there is something to be gained as opposed to lost by going into some kind of international organization that might make a decision about us that some don't approve of. And so that's the hard challenge that one always has in the American political system. And she respected the fact that we did it ourselves. That was, a lot of Americans feel that way. The question, I think, at the end of the day, I focus more on the question of, will this be used unfairly against us? And that's kind of what motivated the American Service Members Protection Act. The sort of feeling that the United States, the indispensable country with 3 million men and women under arms, would be called on to go out there and protect people from terror and atrocity, and might stop a massacre where you save 20,000 people, but might in the process kill 20 people by accident. Then an ICC prosecutor, not the last two, but a future one, could come on and say, well, I'm going to be even-handed. I'm going to prosecute the warlord, and I'm going to prosecute the American, to show that I'm prosecuting both sides. Unfair. And that there's that fear that that kind of thing could happen, and that would restrain our willingness to some extent to become involved in places where we really were needed. So that's what motivates people. On the other hand, the ICC is actually much more contained than the ICTY is. The ICTY actually did open an investigation about our bombing in Kosovo and determined the way we targeted was okay, and that there was no need to proceed, even though innocent people have been killed in the Chinese embassy and elsewhere. We hadn't intended that. We'd intended to focus on military targets. So, and that court was able to go there. The ICC, on the other hand, would have to, if we were a member, would have to show that it was grave. In the case of war crimes, would basically, as a number of standards, require that it be substantial or widespread, and has case law that frankly limits its ability to deal with any kind of case of collateral damage, et cetera. So it's, but over time, the United States, I think, fairly needs to see how prosecutors decide these cases and how the judges decide the admissibility standards, so that we can have confidence that a prosecutor wouldn't be able to unfairly target an American. And that'll take more than 11 years under the court. It took 40 years to ratify the Genocide Convention. But I think that's the concern that people have. Then beyond that, we have to deal with that fundamental question of do we gain more in terms of our ability to effectively challenge atrocities by being in than we risk. And that would have to be a national debate of the kind that we've had when potentially unpopular treaties like the Panama Canal Treaty or other things have been ratified. It's taken that kind of national discussion, and that's for somewhere in the future.
Don't want to get sidetracked on it, but I think you've hit it on the nail on the head there, or head on the nail, whatever way you say it. Right. That there's that discussion about what is to gain from it, and I think I would not again sidetrack the discussion saying there's quite a bit for the U.S. to gain in becoming state party, but it is reality that with us as a country, our history is we to build up to that point. And when the political window opened up for Ronald Reagan to push for ratification of the Genocide Convention, there had been quite a bit of work previous over the years by civil society and within the government, like Senator Proxmire, to push that forward. So we'll stop with one more question in the back here. And I'll turn it over to Nassim after that. Please go ahead.
Hi, my name is Louis Christian. I don't work for the UN anymore, but in 2006 and 2007, I was based in South Darfur for UNMISS. And my question actually related to something Mr. Moreno-Ocampo said. I believe in 2010, he said, and this was in reference to not the massacres in the early phase of the war, but the prevailing conditions in 2010. He said, the people in IDP camps were living under genocide conditions, like, quote, a gigantic Auschwitz. And I'm wondering if, there's any concern on your part that those kind of sort of bombastic and over-the-top statements may have injured the court's credibility in any way, and perhaps detracted from the very real and terrible things that are going on.
Well, that's and I've not heard that particular quote, and prosecutors, even U.S. attorneys, like I used to be, I mean, sometimes be carried away in public statements, try to avoid that,
but not you, of course.
Well, it can happen in any system when you provide when people see these horrendous crimes, become angered. them and are frustrated sometimes about the ability of, at the international level, of bringing two people to account and having guilt or innocence determined. But two things. I mean, one, prosecutors have to be very careful not to prejudge guilt. Certainly, they can talk about horrible crimes that they've committed. They don't have to close their eyes to a mass grave of 1,000 dead. But the question is whether individuals are responsible
Up the use of the word alleged.
Alleged all over the place, as always. But the other aspect of this that I do want to get clear on, and that is that it's very important that prosecutors do speak. Sometimes people who come from European systems take rather uncomfortably to the idea that prosecutors should speak in these international courts. And I certainly gained my lessons in Sierra Leone, where we had a very active outreach program. My predecessors and myself flew around the country, traveled on horrible roads, or went across swollen rivers, etc., to meet with communities and answer questions from every meeting I went to. 1,500 people, the school children, were asking about why we prosecuted this person and not this person. We had this tremendous outreach program, not only by the prosecution, but by the court, which had 13 district outreach officers who showed videos. Of course, if they showed videos, that means they had their generator fueled, generators, and we would project them at night, etc. People were very well informed about the court and wanted very much to hear what court officers said. And sometimes I brought out the chief of the defense unit who would respond to my points. But for people to understand why these decisions are being made, who's being targeted, who's being prosecuted, who's not being prosecuted. It's an enormous power that prosecutors have in systems that are based on discretion, like an international court, where only a relative handful are going to be prosecuted. There has to be a clear understanding of what the standards are, why this case and not another. And so for prosecutors to travel and to answer questions and to express what their standards are. And then, of course, to be out there pressing, as the prosecutors of the ICTY do, Ricardo Ponte, who's hard work for state cooperation and arrests, to bring the people to justice using the levers of conditionality of aid or EU accession, pushing for those kind of levers to be provided. If they don't do that, nobody's brought to justice. The system doesn't work automatically like ours, where an arrest warrant is going to go to the marshal or the sheriff and go out and get the person. You've got to put the pieces together, or it fails. And that requires a great sort of public advocate who pushes that, maintains interest in those cases, passion in civil society to pursue justice, and works that process, all while ensuring at the end of the day that you don't overstate the case and don't prejudge guilt.
Ken, 30 seconds.
Yes.
Ambassador, I think you really hit the nail on the head about joining the ICC. It takes a political window, and it's important to be prepared for that political window. And if preparations have been made, political window appears, and you have an executive that wants to go through it. If things are prepared, it happens. That's often the way of these treaties that take a long time to get out there.
And certainly to the extent we're engaging with the ICC, and if there are issues in which we're involved, that we're explaining, and we're making sure this institution takes decisions that are reasonable and rational and understandable to people of goodwill, no matter where they are in the world, I think that increases the possibility that if there were a window, that people would find it an acceptable institution to join.
Yeah, they're very unpredictable. And I will say one last point on your excellent question is that, I can speak for our working when I was with the prosecutor's office in Cambodia. The most important thing was that outreach and having different representatives of the court. But where the difference really lies with Sierra Leone and Cambodia was that there is no access on the ground in the Sudan and Darfur. And so I would agree with you that that statement is bombastic, and maybe he probably regrets that, but there's quite little that the ICC prosecutor can do in that point because there is no actual operation on the ground. So with that last point, I want to first of all thank everyone for coming and thank Ambassador Rapp, and I'll turn over quickly to Nassim for closing remarks.
So thank you very much, Pip, for moderating, and thank you again, Ambassador Rapp. We're really of information again on behalf of WICC, the Washington Working Group on the ICC. We want to thank you all for coming. We have a couple of briefers in the back. Please pick one up and sign in if you haven't on your way out. WICC is very interested in serving as an educational and informational resource on the ICC in Washington, particularly on the Hill, through briefings like this. And we hope to hold many more in the future, but we also would be very happy to sit down with you or others in your offices if you're interested in learning more. So please get in touch with Kit or me afterwards. And again, we thank you so much for coming.
Thank you, everyone.
Sure, yeah.